Hello, welcome back to English Law. So I'm carrying on about liability, and there's also the proximity test. I was speaking about Donoghue and Stevenson last time. So remember, if there's going to be some liability, there's got to be foresight. The harm must be reasonably foreseeable. And Lord Atkin was the leading judge on this case. So he underscored the necessity of a relationship of proximity between the parties in such an action. But this doesn't mean that they need to be geographically near to each other. So proximity means that in that situation there's some sort of duty of care because there's some connection between them that's not too tenuous. All right. So there's a well-known case called Sudrahar against NERC 2006, which went to the House of Lords in the days when that was the UK Supreme Court. So there was a guy who was living in a village in Bangladesh. He was one of many people who drank some water that was contaminated with arsenic. And he said that the defendant had caused, or at least materially contributed to him falling sick, because the person had not drawn attention to the arsenic in the water when he made a report which claimed the water was potable. The defendants had been granted a contract by the Overseas Development Agency to test the water for minerals and to see whether these would be injurious to, what do you call it, ichthine life. Anyway, they were not supposed to regard whether it was suitable for humans, whether there was any arsenic in it. So the defendant said there was no case here, there was no proximity between them and the entire population of Bangladesh, therefore they could not be found liable. The House of Lords, they concurred with the Court of Appeal decision, and they held that there was no proximity between the claimants and the defendant, so therefore there was no duty to verify that the water was free from arsenic and therefore fit for human consumption. This is what Lord Hoffman said. The principle is not that a duty of care is owed in all cases in which it's foreseeable that the absence of care someone may suffer physical injury. There must be proximity in the sense that a measure of control over the responsibility for the potentially dangerous situation. Such a principle does not help the claimant. The defendant had no control whatever in law and practice over the supply of drinking water in Bangladesh, nor was there any statute, contract or other arrangement which imposed on it responsibility for ensuring that it was safe to drink. So the proving a duty of care is the first thing you need to do if you're claiming negligence. The issue is often argued as the first issue before they look at other things about the case, and that is a very utile way to get rid of feeble claims, just vexatious. And Lord Hoffman went on to observe, when one considers the scale and cost of the trial, the case for stopping the proceedings now appears to me to be overwhelming. Now, there's another very influential case here, which is Anne's against the London Borough of Merton. Now, this is about the legal principle and policy, how they intersect. So I've looked at the first two aspects of the duty test. So how about the test about whether it's fair, just and reasonable? So this three-stage test for the duty of care. And the House of Lords used this in Caparo Industries PLC against Dickman 1990. The Caparo test is vital. In the 70s, judges were usually satisfied to decide whether there was a duty of care and damage and to be reasonably foreseeable, and then that there was proximity, the person was liable. In 1970, Lord Reed, in a vital case called Home Office against Dorset Yacht Company Limited, said that all negligence actions and duty, whether that was in question, they would presume that the Atkin test was applicable, and that would be enough to settle the issue of duty or no duty. However, as the 70s wore on, people began to think that the Atkins test was no longer entirely satisfactory. Why were there such concerns over the restrictions to the Atkin formula? Is because they began to realise that claimants were suffering damage of a kind which broached more complex issues. These weren't necessarily a blatant traumatic injury, and the injury could be sustained due to careless behaviour. So this duty test was established. Economic losses arising from negligent acts or negligent misstatements were very, indeterminate, particularly tricky to decide. They're problematic, and they thought that the two notions of foresight and proximity were not enough, bearing that such losses were mounting, and they wanted the duty test to serve its purpose of restricting liability for injury or loss which arose from negligence. So it was like the danger of loss or the kind of injury that the tort system did not want to compensate would pass the foresight and proximity test. Right, a different component that they then super added to the Atkins test was to permit the notion of duty to carry on as a way of restricting liability. Lord Wilberforce, he was the judge sitting on Anne's against Merton London Borough Council in 1978 when that went to the appellate court. Although, incidentally, this is no longer had to be valid law, the findings in that case. So he thought he would introduce an element which was theretofore missing. So this is what Lord Wilberforce had to say. The duty question is to be approached in two stages. First, one has to ask whether the alleged wrongdoer, the person who suffered the damage, there is a sufficient relationship of proximity, of neighbourhood, such that, in the reasonable contemplation of the former, carelessness on his part would be likely to cause damage to the latter, in which case a prima facie duty of care arises. Secondly, if the first question is answered affirmatively, it is necessary to consider there any other considerations which ought to negative or reduce or limit the scope of duty or a class of person to whom it is owed, and the damages to which a breach may give rise. Close quotation. So stage one in Anne's, it includes Atkins' neighbour principle. The second part is about policy factors which may vitiate, reduce or restrict any duty, and the policy reasons for these. So there is a obvious distinction in Lord Wilberforce's test between the legal principle and the policy, because in this test the legal principle decides whether there's a duty of care or not. That's the first limb, and the second limb is about policy, which might then work to reduce or exclude altogether the duty. Now, Lord Wilberforce's test has come under fire from scholars of jurisprudence and other jury consults. So the Anne's test has been castigated particularly because it tries to separate principle and policy. Some people say that this separation will lead to wrongful and unjust decisions. It's made the law more unclear over the issue of and the function of the duty concept, so many judges say we shouldn't muddy the waters there. So reasoned from that perspective, the function of duty of care is hard to say if policy did not inform itself about the duty issue. So if we accept that the purpose of the duty of care is to restrict liability for reasons of policy, then it must automatically follow that the duty of concept is made up mainly of policy components. So whereas the Lord Wilberforce test would suggest that it's not. Now, the first negative repercussion of the separating the principle and policy is that policy was not clearly engaged in a judge's rulings, and that the test separates policy components from the matter of whether duty is found or not. So judges then, as today, are aware of how vital policy considerations are to all aspects of the duty test, but and that's against Lord Wilberforce's formulation. So it was thought that policy factors are there to decide whether there's a duty or not, and there's no issue if there's no issue of the duty arising at all, then policy factors very much imply that the case in front of the court is not one in which you can justify spreading or shifting the claimant's loss onto anyone else. Now, this second harmful consequence that's thought to have come from Lord Wilberforce distinguishing policy and principle is that Lord Wilberforce, his approach to the duty issue was thought that to make liability too broad instead of restricting liability. So, in summary, what he did was the exact opposite of what he intended to do. The newer negligence claims are often litigated successfully. Although in the time when Anne's was still held to be valid law, it was authoritative, liability and tort did not broaden towards solely economic loss inflicted through negligence. After the Anne's case was overruled by Murphy in 1990, liability for negligently causing pure economic loss has been seriously restricted. So it is vital to underscore that the second limb of the Wilberforce test in quintessence means that the conceptual origins of fair, just and reasonable criteria are there. They introduce a more, just a pellucid engagement with the policy factors when you're judging on this issue of duty of care. So how about fair, just and reasonable as per Caparo? So the main response to this period of ever-expanding liability after the Anne's decision meant that judges in the late 80s into the 90s were increasingly dubious about the issue that Lord Atkin put in Donoghue and Stevenson. Remember that Lord Atkin was trying to find a general conception of relations giving rise to a duty of care, of which the particular cases found in books are but instances. That's exactly what Lord Atkin said. So Caparo Industries Public Limited Company against Dickman 1990. So this is an appellate court ruling. And that's a case that I'm going to delve into in greater depth in a subsequent video. So it's about negligent misstatement. But it's vital to look at this because it lays down what's a tripartite test. And this is a rather broad ratio in Caparo. This is what Lord Bridge said. In addition to the foreseeability of damage, necessary agreements in any situation giving rise to a duty of care are there that should exist between the party owing the duty and the party to whom a relationship characterised by law as one of proximity or neighbourhood, and that situation should be one in which the court considers it fair, just and reasonable that the law should impose a duty of a given scope upon the one party for the benefit of the other. Close quotation. Incidentally, proximity and reasonable, these are synonyms in tort law. So we have to ask why Lord Bridge thought that principles such as foresight, proximity, and so on, even though they're important in evolving the law of negligence, were no longer to be depended upon in these new duty situations. So this is what he said, and something that other judges have applauded in other cases. These terms, and this is a quotation, are not susceptible of any precise definition, as would be necessary to give them utility as practical tests, but amount in effect to little more than convenient labels to attach to the features of specific situations, which, on detailed examination of all the circumstances, the law recognises pragmatically giving rise to a duty of care, given scope. All right, so let me remind you what the Caparo test is. Here's a précis. So the three stages to it. 1, there's foreseeable harm to the claimant. 2, there is neighbourhood or proximity between the parties. And 3, that it's fair, just and reasonable for there to be a duty in the circumstances. Now you see what you need to do is to apply this tripartite test. The duty of care hasn't previously been found in a similar set of facts. That's enough at the moment. Toodaloo.